It still means far too many students are experiencing anti-LGBT violence and discrimination. Joining us now, we have Paul Katami and Jeff Zarrillo, plaintiffs of Proposition 8, the California ban on gay marriage that was overturned. I want to thank you both for joining us this morning. So Paul, the thing is that this survey says that it's actually discriminatory policies in the schools that are still in place, that are still really affecting students negatively. So what more can we really see schools do here?
Well, I think it's a policy issue, but it's also a personal issue. And so if you listen to the kids that are being affected by this, we need to move policy faster. A lot of times you meet these barriers and these thresholds that take so long for a school or for an organization to make changes to their policy to protect these poor kids that are dealing with this. And we see bullying as a major issue here. I mean, we talk about LGBTQ rights, but these kids are in school dealing with it every day. And we see that now youth, younger and younger, coming out, accepting who they are, identifying as they should, and they should be protected.
Well, I think you have to talk about the teachers in this case too, because if you look at the results of this survey, Jeff, it said that a lot of the time students heard teachers making homophobic comments, and or they didn't see teachers stepping in if some kind of bullying was going on. Clearly it's not acceptable for teachers to be making homophobic comments, but where do you also find the balance of when a teacher is expected to get involved in something if they see bullying?
Well, I think it's not even just with LGBT issues and bullying in school. It has to be, teachers need to set the tone. Teachers need to set the example. They need to step in when any child is being bullied. They need to step in when any child says something or somebody says something to them that's inappropriate in any way, whether it's LGBT related or something related to the way they're dressed or anything like that. They have to really set that example so that the kids in that classroom know what is an acceptable standard going forward.
That's right. All right, now there's some bad news for Puerto Rico's LGBT community. A United States district judge rejected an appeal to the region's ban on same-sex marriage on Wednesday. Judge Juan Perez Jimenez said that the decision wasn't up to the judges, but to people and legislators. And in a 21-page ruling, he said because no right to same-gender marriage emanates from the Constitution, the Commonwealth of Puerto Rico should not be compelled to recognize such unions. Instead, Puerto Rico, acting through its legislature, remains free to shape its own marriage policy. 5 gay couples were behind the lawsuit, and according to the judges, they will now file an appeal. Now, Puerto Rico is the only jurisdiction under the First Circuit Court of Appeals that does not allow for same-sex marriages. Earlier this month, the Supreme Court decided that it would not hear appeals from states trying to uphold same-sex marriage bans, and since then, over 30 states now recognize same-sex unions in the states. It seems like the tide is certainly turning, but one of the things that we did see was the judge reference the Supreme Court's United States versus Windsor ruling here. Tell us a little bit about why that case was relevant.
Well, the judge used Alito's dissent. And we know through history that dissents are there only because they're the opinion of a judge after the law has been interpreted correctly. And that's how we see this, is like in Windsor, and in our case, in the Prop 8 case, the law was interpreted correctly, and we see this tidal wave of judicial decisions that really boost that, and they basically they let us know that the law is black and white, and that if you have a personal bias or discrimination against what you believe traditional marriage is, and they use these tired kind of defenses that have been proven in courts, decision after decision, that procreative rights and traditional marriage definitions, they don't stand up to the law. The law talks about, our Constitution talks about treating people equally. So that's why we rely on that 14th Amendment, and we rely on the tidal wave of decisions to make sure that we continue that momentum. We're at 32 states right now that have marriage equality, that recognize it, and I believe that soon we'll be at 50. Perhaps these decisions will allow the Supreme Court to finally step in and make it, a 50-state ruling.
Well, what was your reaction when the Supreme Court decided not to hear any of the cases regarding or relating to marriage bans in states across the country?
I was floored just because there were so many cases in front of them that I thought they would step in with at least listening to one of them. But we got a little tease a week before that when Judge Bader Ginsburg said, well, there really isn't any split in the courts yet. They look for circuit courts of appeals to have splits because the Supreme Court is there as the referee. They'll step in and they'll interpret the law the way it should be so that they're consistently applying the law throughout the entire country with regards to that. But because there was no split, and we may potentially get a split in the Sixth Circuit. I mean, a lot of people think that maybe that's the case, that if we do lose one, we potentially could lose the Sixth, which would require the Supreme Court to step in and say, okay, once and for all, what is the law? How should it be interpreted? And how should we treat everybody in America?
But it's an odd position to find yourself in, almost hoping that a case is lost in order to get the Supreme
Right.
Court to
Right.
weigh in. And even here in Puerto Rico, they're saying that an appeal is going to go through. You guys know this process all too well, right? Is that it's one appeal after another to make it through the judicial system. What's that like when you guys were going through it?
I would say even with the fact that the Supreme Court didn't take a case, I think that also sends a message that the Supreme Court doesn't necessarily think that these federal judges are interpreting the law incorrectly. If they really thought that these federal appellate courts were interpreting the Windsor decision incorrectly, they would have stepped in, and they didn't step in.
Yeah. And it takes time. That's the biggest thing for us. It took us 5 years to attain the rights that we deserve in California, to basically bring that right to marriage back to California.